To get started, welcome to the Harpswell Select Board meeting of Thursday, May 1st, 2025. We'll start with Pledge of Allegiance.
Allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Up in the agenda, I see nothing else. And at this point, we'll open up the public hearing at whatever time it is.
7:05.
At 7:05.
I'm going to recuse myself because of the perceived conflict. There is no conflict of interest, but because of the perceived conflict of interest that there may be concerning this matter, I am going to recuse myself and step down.
All right, thank you.
Well, I would think that you could participate in the conversation, but just no voting.
I don't, yeah. Do you want me to move to the
I
public?
think that is the procedure.
That's fine.
If you're going to recuse yourself, then you participate from the audience and not as a member of the board.
Yep, no problem.
Yeah.
All right, who do we want to start with?
Do you want to give an overview,
Yep.
please? Thank you. Town Attorney Amy Chow, Drummond Woodsum.
Yes, good evening, everyone. The last time we were here on this matter, I looked on my calendar, was September 19th, 2024. I am not going to take you through all of the history, but I think just enough to get to the state that we're in with this proposed consent agreement, which I understand has been provided, it's been noticed, and everyone has reviewed copies of this.
Yeah.
So going back to fall 2023 and into the winter of 2024, the Code Enforcement Office became aware that there had been work done on this pier or dock. I think you've all seen photos of the dock. It's in disrepair. The work that was done by the owner at the time, there were additional pilings and structural elements added, all without a permit. And so when the code officer found that, there was a notice of violation that went out in April of 2024. And essentially, without getting into the details, and Mr. Clough's attorney is here, and she can provide the landowner's perspective on this, but it was the code officer's belief that the work that was done on this dock in the winter-ish of 2024, that the landowner believed he had the right to do that work without a permit because it constituted maintenance and repair. And that has been sort of the essential sort of dispute here. The code office believed, no, what you were trying to do is sort of reconstruct it. It's of no use to anyone unless it is actually reconstructed so it can be usable, and it is a total reconstruction that needs to happen, and you can't piecemeal maintain and repair it to get it back into usable shape. So fast forward, originally we were here in September with the idea that the landowner would seek after the fact permits. I don't need to get into why that didn't occur. And then in the fall, in October, the landowner did seek after the fact permits, and he did. By the way, a stop work order was issued in the spring, and the landowner has complied with that. There has not been any work done to the town's knowledge since that winter of 2024 timeframe. So in October of 2024, the landowner did apply for an after the fact permit, and that after the fact permit, you recall there are two permitting provisions in your shoreline zoning ordinance that we believe potentially could apply in this situation. And one of them is under 10.3.2.2, and the other is 10.3.2.3. 2.3 has basically is the kind of permit that you would need to get if the reconstruction of the non-conforming structure requires that the amount of work that you're doing is less than 50% of the assessed value of the structure. I'm paraphrasing. It actually says something much more specific than that, but that's the general gist, is that in order to reconstruct it, make it usable, you would be spending less than 50% of the assessed value of the structure as measured by what it says in the ordinance. That's 10.3.2.3. 10.3.2.2 is a reconstruction effort of a dock like this that essentially is a rebuild and that would be reconstructing it because 50% or more of the structure, of the assessed value of the structure, is what is necessary to complete the work. And under that provision, if you are in the 50% or over amount of work, if you will, based on its assessed value, then you have to move the structure to the greatest practical extent. In other words, you have to engage in an analysis of whether or not the structure, if you had to completely reconstruct it or more than 50% do that, can you make it more conforming? And you need to try to do that to the greatest practical extent. Originally, what I will say is I think it was in the fall of 23, the landowner did actually apply to completely rebuild the structure, but not move it in any way or not adjust it in any way. That was denied. That wasn't appealed. So why are we here today? I think that the figure is actually quite helpful. The landowner has gone back with a designer, Tim Forrester, a flycatcher, and has, instead of leaving the dock in place, the proposal, and I will let Kristen Collins outline exactly what this does, but I believe the attempt, as you can see on this figure, is that the original structure, a portion of that structure will be removed so that there is no longer an encroachment over the riparian line of the abutter to the west. And then what will happen, and this structure would be reconstructed, that's the wharf that doesn't move, the portion of the structure that doesn't move, will be reconstructed with a portion of it lopped off so that there's no encroachment on the riparian line on the west. And then what will be added is a ramp and float system. Obviously, that's temporary. That's not a permanent thing. And there is an understanding that there's further permitting through the Code Office and the Select Board through the Wharf and Weirs Act for the extension further into the resource caused by the ramp and float. And any extension in the resource that could occur, it doesn't seem like they are proposing that that will occur. But if it does occur, then the Select Board would see that. With the actual permanent part of the structure, then the Select Board would be reviewing that as well. And so with that design, proposed design, the consent agreement that is before you tonight essentially the essential terms are that the Code Enforcement Office has reviewed this, and subject to this is only a preliminary design, it hasn't been surveyed yet, but subject to an application being filed when a surveyor can draft a site plan and can do this in such a manner to A, remove the encroachment on the riparian line on the west, and B, not create any other new nonconformities on the east or anywhere else within the shoreline zone. If that can be done, then the Code Office is prepared to publicly opine that this proposal would meet the greatest practical extent standard in the ordinance. Now, what your ordinance does, and I'm maybe going too much into this, but there's a section in your ordinance that says that when a greatest practical extent analysis like this needs to be done, it can go to the code officer or it can go to the planning board if the planning board asserts jurisdiction. So at this point, it's not known who it's going to go before. But if it does go before the planning board, then the code officer is prepared to publicly state that this would meet the greatest practical extent in the code officer's view. That doesn't mean that the planning board, if the planning board reviews it, has to take that has to take that opinion, but the planning board certainly can take that opinion into consideration. So that's, in essence, those are, in essence, the major terms of the agreement. There also is a provision for the owner to come with an application with the opinion of a marine expert who would say that this also, from an engineering or siting standpoint, would meet the greatest practical extent standard. So a survey, a marine expert, that would come before either the code officer or the planning board. Then there would be additional Wharf and Weir Act proceedings that this consent agreement does not cover. And for that, the owner, I will say I have been in contact with the attorney for the owner and also with the code office, and we have agreed on paragraph 7 that the owner, in consideration of this consent agreement and having this process being able to be moved forward, that the owner would pay the town $10,000 to defray the town's legal costs and fees to date. So I think I've covered the main elements of the agreement. There are many pieces because there are lots of applications and appeals pending, and I don't really think we need to get into that unless you have a very specific question about that. That covers the substance, I believe. And you'll want to hear from the attorney for the owner, of course. Any questions, though, for me at this point?
I don't think so. I've been following it since the beginning, so.
Okay.
Kinda.
All right, very good.
Good evening. I'm Kristen Collins. I do represent the Cloughs. I've also been following this from the beginning. I went back and looked at the versions of this consent agreement or various consent agreements that I've written, and the first one that I saw was sent actually back in July of 2024. The basic framework that you have in front of you today is from December of 2024, I think was when we first started talking about this framework. Amy and I might be the two busiest municipal attorneys in the state of Maine. So I hope you don't feel that, there's been delay on the part of the Cloughs. It takes a lot for the two of us to exchange these red lines back and forth. And I think we've worked in really good faith to get to where we are. If you remember when we were back in front of you, which I do think was in September, we broke down over the penalty payment, which I think we were asking for $3,000 and the town was asking for $5,000. And the reason that broke down was because there was really no path forward that was baked into that. And Mr. Clough was in the position of potentially losing this nonconforming structure, which frankly had done the work to try to protect from the beginning so it didn't wash away and he didn't have the ability to rebuild it. This structure under the agreement works because it provides a path forward that allows for a better dock to be there. The Cloughs don't want the dock that's there. I'm sure the neighbors don't want the dock that's there. And the town shouldn't want the dock that's there. What this proposal does and what this design that we've had Tim Forrester sketch out does is it does minimize the amount that this encroaches into the neighbors' riparian lines to the west. It also just cuts down on the overall square footage of this structure. As a town, we want as minimal of structure in the shoreland areas as possible. And this does cut down on that. And for the neighbors, it means that for a large part of the year, they will not be seeing, as much structure even as there today because the ramp and float will be gone off season. In terms of the greatest practical extent argument, the point here is that it's always best to leave things in place. And here we have tie-ins to existing ledge. There's no more ledge if you move any further. And we have very little wiggle room to move anyway because it's narrow riparian lines. To move it any further than is being done here would require a bunch of cribbing to be built, which, can be done, but is never as stable as tying into ledge, and also creates a lot more disturbance in the shore. So there's a benefit to keeping it where it is. And that's why, Tim Forrester would be designing this plan, and why I think the CEO is prepared to opine that it meets greatest practical extent. So, frankly, again, that is what the Cloughs had intended to do from the time they bought this property. There is pending litigation, regarding the dock and whether it is, to confirm essentially the rights for it to be where it is, and also about the property line. But the beauty of this plan is that it's not asking for anything different than is already there, and it's minimizing what is already there. So we do agree to the $10,000. It's taken us a long time to get to that number. I want you to understand that the Cloughs are taking a gamble with this. There is a possibility, for whatever reason, that the planning board, if it takes jurisdiction over this, might deny the application. I can't think of why or how they could, but there is a world in which the Cloughs have paid $10,000 here and they still don't get a permit. And that's a risk. And that's something that keeps the number they're willing to pay at this level. And we all hope, though, that this permit is issued, that it doesn't go back to an appeals process. But it is important to realize that if that were to happen, and we go back to an appeals process, that's a lot more legal fees for everyone, and it's a lot more uncertainty at the end of the day, and it just doesn't seem good on either side of the equation. So thank you for hearing us. Thank you for having a special meeting to, I think, accommodate largely our schedules, and let me know if you have any questions.
All right. Where do we stand?
You want to hear from the public?
Yeah. Probably ought to. I want to hear from David first.
Oh, okay.
But, sure.
My name is Gail Hunter. I'm the property owner and full-time resident at 25 Field Road, which is the adjacent property to 28 Field Road, or the lot numbers. I'm here to make comments on this commitment and to also preserve the right to appeal. I'd also like to address the CEO and town hall or council as far as notification of allowing people enough time to review, adequate enough time to review the documents. This drawing of the flycatcher's drawing, Exhibit A, was done on 4/28. Also, I was not told of this hearing. The only way I found out about it was through the agenda, through the general email to the public. And considering my involvement and lawsuit involved in this, I think that we should be notified individually on something like this rather than general public. If I had not opened up the agenda, I would have missed the meeting. Looking at the documents, there seems to be confusion as far as, if the town approves it, it goes away. If the town doesn't approve it, it doesn't. We're looking at two applications that look like they're separate for the reconstruction and relocation, and then the float and the ramp. I'd like to address comments to Exhibit A, which is the flycatcher drawing. The Flycatcher LLC is basically a consulting firm. I don't believe, and I have not located anything that states that it is registered or licensed in the state of Maine as a survey company. The drawing also does not meet the requirements of the survey, the ordinances, the setbacks, dimensions, etc., depicting what's permitted. There was a drawing done, actually a survey done, in 2005 called the Owens-Haskell Survey. It is deeded, recorded, they're licensed, etc. And it shows the boundary property lines. I'm going to let you borrow this just to look at it during this meeting. And you'll see that the difference between Exhibit A and...
I've seen it.
I have, but I'll refresh myself.
That the difference between Exhibit A and the Owens-Haskell drawings are discrepancies with the actual property line. The Owens-Haskell drawing shows about 50% or more of that dock on my property to date, and the flycatcher drawing does not. The Owens-Haskell's drawing meets the requirements for a land survey or the boundary plan and boundary survey. So if we read the notes on Exhibit A, you'll see that they say the base map imagery is based on Google Earth at 18 feet, it looks like. And the prosperity line data is based, there's an undated site plan, is based on James Clow, and the plan's a draft, and it's not for permitting purposes. So it's basically a sketch and cannot be used for permitting. It doesn't meet the requirements. So we're asking that the town, we object to the document, to the attachment of the consent, and we're asking that the town remove the sketch or Exhibit A from this attachment. Referring to paragraph 2, this paragraph is also confusing and contradiction as far as the encroachment and setback violations. Basically, it states there's not going to be a violation, and then it says it will be a violation if we attach it to the ledge. Also, who is the dock construction expert? How is that defined? Who determines that without bias? What is the CEO's role in this? Why is the CEO agreeing not to be challenged? The town cannot allow encroachments on my property. This property is non-conforming, cannot meet the setback requirements, location in regards, or not to set back to the greatest distance to allow for the ledge or not. I believe 25 feet still prevails from as the setback from the adjoining property line. That's on the east side or the west side. The property is not wide enough to allow for either. Basically, and in conclusion, this is a case of measurements as a starter. A determination of location of the property line, we need to measure from, and it's a starting point for measurement where the line is and where we go from there. If that is not determined, nothing can go forward as far as building or permits or such. We really need to know where that line is. On page 2, paragraph 3, it states the lawsuit may affect the scope of the project, yet until determination of location of the common property line, that's impossible. So, those are my comments. I have reviewed them with my lawyer, who's not here, because of health reasons. Thank you very much.
Okay, anybody else?
Matt Gilly. I just have a couple of questions. Reading 10.3.2.2, it says that may be reconstructed or replaced provided that a permit is obtained within 18 months. This is far beyond 18 months that this has been in this condition. Why are we allowing them to even apply for a permit that they shouldn't even be eligible to apply for? And my second comment is, what if we're finding them $10,000, what were the town's total legal fees in this endeavor, and who is responsible for the remaining balance, the taxpayers? And that's all I have. Thank you.
I can answer the legal fees question. So we started expending legal fees on this case in May of 2024. For the entire year of 2024, total legal cost $21,752. So far, we've had 3 months' worth of invoices totaling $3,354 in 2025. So we're into it for over $25,000 at this point. I will say early on, a lot of the legal work was to support the code enforcement officers' notice of violation situations, and then also providing support to the code enforcement office as it went before the Board of Appeals, actually. So not all costs are specifically affiliated with the consent agreement and the drafting and the back and forth. It did involve code enforcement and Board of Appeals.
Anybody else want to speak to this? Pardon?
I'll say a couple words if there's.
Oh, sure. Yeah.
Just to address some of that, I mean, certainly this is not all over in the sense of making the case to the permitting authority. We've got to submit a plan as part of this agreement that's prepared by a surveyor that's going to show all of these points of interest. And I think that Amy would be in the position, as we often are, to tell the planning board that when there are questions about the location of boundaries, what matters is that the applicant presents with evidence, even if that evidence is disputed, that they have right title and interest. And there's really good evidence that there's right title and interest to this dock because this dock has been there for 40 years. So that will be a discussion that Ms. Hunter can participate in at the planning board with her lawyer or without. And on the point of legal fees, actually, just on the survey, we're not here to litigate what the boundaries are, but it is really important that there is a piece of ledge there. That's the defining point in these surveys. And we have it on very good information that there was an error in the survey that was presented by Ms. Hunter tonight in terms of locating the southern tip of that ledge. So on the legal fees, just something I wanted to point out is not only that a bunch of this was spent on the Board of Appeals process, but some of it too was presented in evaluating our application that we put in to cure the first notice of violation. The Cloughs were told to request approval of the work they had done, and they did so. And the town had to, look at those permit applications and ultimately ended up denying it. And at the same time the town did that, it also revoked the notice of violation that had been pending since April of 2024 and replaced it in December with a new notice of violation. So in terms of those legal fees, in my mind, a lot of that was attendant to a notice of violation that ultimately got thrown out by the town itself and replaced with a new version. And we've been negotiating since December on this new notice of violation that replaced the former one. We often, as municipal attorneys, counsel our clients that what we're trying to do is stop the bleeding, bring things into compliance, and not create the promise of future legal fees down the road. And this agreement does all of that by creating, I think, what is the quickest possible path to bringing this structure into compliance. About that 18-month rule, that 18 months goes from the date that the structure, the dock in this case, was destroyed or removed. And so it hasn't been destroyed or removed yet. It's still there. It would be removed and replaced as part of this project. And the 18 months would run from the date that it's actually removed. So that's all I have, unless you had any questions for me.
I don't think so. You answered the questions that
Thank you very much.
taken up. So thank you.
Exactly.
just wanted to add one fact regarding notice, so it is of record. Our office did email the draft consent agreement with Exhibit A to Ms. Hunter's attorney yesterday.
And my office let her attorney know about this last Thursday, I believe.
Okay.
And on the question of the CEO agreeing to not challenge the replacement dock application, I'm assuming that's to kind of try to put this thing to bed? Because that question was brought up. Just thought I should answer that. Sure, whoever can answer it.
Well, I don't want to speak for the code enforcement office, but in discussions.
Well, it's in the consent agreement. So.
Yes, it is.
Yeah.
It is. And I think I'll go back to initially the very first application that the landowner put before the code officer was to reconstruct it entirely in place. And the code officer's denial of that said, you have not made any attempts to make this dock more conforming. And so that was the basis of the denial. So what I will say is that this is a different plan, and if it can be accomplished through a surveyor, et cetera, the code office was prepared to say that it meets the greatest practical extent standard.
Yeah. It's starting over. The survey's done, and the permit process starts over from fresh, like it wasn't there.
And Section 2 does require the survey,
Yeah.
a new survey.
It's in the agreement that a new survey be done. And we're familiar with Flycatcher's work, and we, as a town, we stand by his work. We see it all the time.
Still, I think there should be a survey and take the best 2 out of 3.
Oh.
So when item 2 is accomplished, that will do that.
Yeah. So, you about to make a motion that we accept this consent agreement?
Sure, I'll make that motion.
And does that, just, you concur with the penalty provision that was put forward?
Yep.
Okay.
That'll be part of my motion then.
All right, I'll second it. All in favor?
Right.
Yeah. It's over.
Months of misery are over.
Oh,
Did you want to adjourn the meeting?
yes, I do. At what time?
7:37.
7:37, we're adjourning the public hearing.
In the meeting.
And since there's nothing else on the agenda,
Yep, if nothing else, at this point, we're adjourned.
Okay. So is everyone signing now? Oh, I need, okay. That's this.
that's my personal
Sorry.
exhibit.
Oh,
That's okay,
catching
that's
me.
okay. That's all right.
You know, I feel bad for her. The same time she gets off.
It's okay, Amy, we'll use that one. I'm kidding.
Would the Cloughs like to sign? Oh, okay. It's adjourned. Yeah.